In this video, we'll be doing the displacement and rehabilitation policy. Now, the displacement and rehabilitation policy of Jharkhand was published in the Jharkhand Government Gazette on July 25th, 2008. Jharkhand displacement and rehabilitation policy is divided into a total of 9 chapters. Important points in this policy are included here. Now, chapter 1 is introduction. On reviewing the historical events of state of Jharkhand, it is clear that there were many revolts by people of Jharkhand, especially by tribal chiefs, as they were agitated against outside interference in their civilization and customs. After getting independence, tribes and local people demanded a separate state to protect their interest, for which they waged a long struggle. As a result, on November 15th, 2000, the concept of a separate state finally came true. Now, the people living amid the abundance of natural resources in Jharkhand believed that their future would be golden with the industrialization of the state. Earlier, lots of land were acquired under the Land Acquisition Act of 1894 and Coal Bearing Areas Act of 1957 for setting up industries, dams and mines. Large numbers of people were displaced due to land acquisition and lost their forest, land, water resources, community identity and livelihood. Therefore, in view of land acquisition for industrialization and industry, it is necessary that after thorough assessment of the present situation, the resettlement and rehabilitation policy should be prepared so that the welfare of the capital investors as well as people affected by it can be ensured. In the last 60 to 70 years, there has been a significant increase in the number of people coming to Jharkhand for employment, which has adversely affected the social, economic, political and cultural identity of the people of Jharkhand, especially the tribal people. Now, the population of tribes in the state has decreased from 50% in the year 1931 to about 26.3% in 2011. The number of seats reserved for the members of scheduled tribes in Legislative Assembly decreased from 32 in 1971 to 28 due to a decrease in population of tribes in the state. Similarly, the number of seats reserved for tribes in Lok Sabha decreased from 7 to 5 in the state. Now, under the principle of paramount rights, the state is sometimes required to exercise legal power while acquiring private property for providing public facilities and infrastructure. Due to this, people have to leave their land, livelihood, shelter, leading to a psychological, social and cultural impact on these people. It affects the scheduled caste, scheduled tribes, marginal farmers, women and weaker sections of the society most. It is an imperative need to accept rehabilitation and resettlement issue as a fundamental part of the development process designed with the active participation of the affected people rather than as an externally imposed requirement. Families adversely affected by involuntary displacement have to be provided additional benefits in addition to the monetary compensation. The situation is even worse for those who do not have legal or recognized rights in respect of land, such as Gair Maujura and forest landholders on which they completely depend for their earning or livelihood. Thus, there is a need for planners to involve those who are affected by acquisition of such assets in displacement and rehabilitation and resettlement process. In light of the above mentioned facts, an acute need was felt for resettlement and rehabilitation policy in Jharkhand. Now, Chapter 2, the purpose. The objectives of the Jharkhand rehabilitation and resettlement policies are as follows. Preferment of minimum displacement, no displacement or minimal displacement alternatives as far as possible. Ensuring adequate rehabilitation package with active participation of affected persons and speedy implementation of rehabilitation process. Excuse me. Now, the objectives of the Jharkhand rehabilitation and resettlement policy are as follows. We have done till here. To ensure that special care is taken to protect the rights of the weaker sections of the society, particularly members of scheduled castes, scheduled tribes, and the action is taken with care and sensitivity in regards to their treatment. To make joint efforts to provide better standard of living to the affected families and to provide means of income. To integrate rehabilitation works with development plans and implementation process. Where displacement is due to land acquisition, there should be cordial relations through mutual cooperation between the acquiring body and the affected families. Now, definition. The following are the key definitions of the various expressions used in the policy. Affected family is a family whose property due to acquisition of land for a project or for other reasons affected by involuntary displacement. So it should be involuntary in nature. Now, affected area, an area where there is a possibility of displacement of 100 or more families due to land acquisition for a project or for any other reason. Agricultural labor, a person who has been residing in the scheduled area for at least 30 years and non-scheduled areas for at least 15 years before the date of declaration of such area and has acquired agricultural land by manual labor in that area. Agricultural land, such land which is used for agriculture or horticulture, dairy industry, poultry, farming, fishing, sericulture, or as a nursery for production of medicinal herbs for grazing animals, growing grass, etc. Now, displacement, it means losing the home, land, or residential place. Now, family consists of a person, his or her spouse, unmarried sons, unmarried daughters, unmarried brother, unmarried sister. It includes a person, his or her spouse, minor children, and a nuclear family. Separated family includes unmarried man or woman above 30 years of age, physically or mentally handicapped persons with more than 40% disability, minor orphans who have lost both parents or widow. Now, Gram Sabha has been defined in the Jharkhand Panchayat Raj Act of 2001. Holding area, total land held by any person or occupant or tenant in both the forms. Rayat, a person whose name is included in the revenue records relating to the block of land in question. Land acquisition, land acquired under the Land Acquisition Act of 1896 or any other law of the state government. Municipal area, it is defined in the Jharkhand Municipal Corporation Act of 2001. Occupant, such a member of scheduled tribe community or other forest dwelling community whose was in possession of the land before the date of December 13, 2005. Now, project here means involuntary displacement as a result of land acquisition. Acquiring body, a company, a corporate body, an institution, or any other organization for which land is required by state government. Resettlement area, an area which has been declared by the state government as a resettlement area. Now, assessment of the social impact of the project. Whenever there is a desire to start a new project or to expand an existing project which involves involuntary displacement of 100 or more families collectively in an area, the administrator shall ensure that assessment of social impact in resettlement and rehabilitation should be carried out in the affected areas. While carrying out the social impact assessment, it should be taken into account that what impact the project will have on public and community properties, infrastructure, community ponds, postures, land for fodder, plantation, fair price shops, panchayat houses, cooperative societies, and so on. Public utilities like post offices and seed stores, irrigation, electricity, health centers, park, training centers, community centers, places of worship, burial grounds, crematory, etc., and tribal culture. In the case in which both environment impact assessment and social impact assessment are required to be done, matters related to social impact assessment will also be included in the public hearing held in project affected areas for environmental impact assessment, and the work of such public hearing shall be completed within 30 days. Approval of social impact assessment shall be mandatory in all those cases where there is an involuntary displacement of 100 or more families in an area collectively, and the conditions laid down in the approval of SIA shall be followed by all concerned parties. Before starting the process of land acquisition, the applicant body will have to give written commitment certificate to duly comply with the provisions of the rehabilitation and resettlement policy. Now, appointment of the resettlement and rehabilitation administrator and commissioner and their powers and functions. Where the state government is satisfied that the acquisition of land for any project or any other reason is likely to lead to involuntary displacement of 100 or more families, the state government may by notification appoint an officer not below the rank of deputy commissioner as resettlement and rehabilitation administrator. In case of projects involving displacement of less than 100 families collectively, the deputy commissioner shall be responsible for resettlement and rehabilitation of the affected families under this policy. The resettlement and rehabilitation administrator will be assisted by officers and employees as decided by the state government. Under the supervision, direction, and authority of the Rehabilitation Commissioner, the Resettlement and Rehabilitation Administrator shall take all measures for displacement and rehabilitation of the affected families. The power of overall control and supervision with regards to preparation, execution, and monitoring of the resettlement and rehabilitation plan shall be vested in the Resettlement and Rehabilitation Administrator. Under the orders of the state government, the Settlement and Rehabilitation Administrator shall perform the following function and duties. In consultation with the acquiring body, to work as for minimum displacement for person and identify such alternatives for which will not lead to displacement or will lead to minimum displacement. To hold consultations with affected persons and the concerned Gram Sabha while preparing the rehabilitation and resettlement scheme. To take into account the interest of scheduled tribes and adversely affected persons belonging to the weaker section. To prepare draft plan for resettlement and rehabilitation scheme under this policy. Preparation of budget including estimated expenditure for various components of land acquisition, resettlement and rehabilitation activities or programs in consultation with the representatives of the affected families, concerned Gram Sabhas and acquiring body, to arrange adequate land for resettlement and rehabilitation of the affected families, to provide benefits to the affected families, to perform such other functions as the state government may by order in writing assign from writing time to time. The administrator shall be able to take help from any technical expert institution for execution of his work, and the expenditure of this shall be borne by the executive body. The Rehabilitation and Resettlement Administrator may by order in writing delegate such administrative powers and duties assigned to him to any officer not below the rank of circle officer or equivalent officer. All officers and employees appointed by state government under this policy shall be subordinate to the administrator for resettlement and rehabilitation. The state government shall appoint an officer of the level of commissioner or equivalent to be called as Resettlement and Rehabilitation Commissioner for all cases of resettlement and rehabilitation under this policy. Administrative and any other officers as well as all employees appointed to implement this policy shall be under the Commissioner for Rehabilitation and Resettlement. The Commissioner for Resettlement and Rehabilitation shall be responsible for formulation of schemes under this policy to supervise the proper implementation of the schemes. Now, Chapter 6. This is going to be a long chapter. Resettlement and Rehabilitation Plan. The procedure or process mentioned in this chapter shall be followed for declaration of the affected areas, surveys, enumeration of affected persons, assessment of available government land and land to be arranged for resettlement and rehabilitation, declaration of resettlement area, preparation of scheme or plan as well as for final publication. Now, if there is a possibility of involuntary displacement of 100 or more families collectively in an area due to acquisition of land for any project or for any other reason, the SIA within 15 days of approval through an order shall declare the area or place of village as affected area. Every announcement made under this policy shall be published in at least 3 daily newspapers, out of which at least 2 shall be in Hindi language, having circulation in the villages or areas likely to be affected. After announcement, the administrator for resettlement and rehabilitation shall conduct a baseline survey enumeration to identify individuals and finally families likely to be affected. Now, in this survey, the village-wise information about the affected family shall be given accordingly as now the members of the family who are living in the affected area, since when they are living, in which trade or business professions they are engaged, agricultural laborers or non-agricultural laborers, families belonging to scheduled caste and scheduled tribes, primitive tribes and other backward classes, disabled, destitute, orphans, widows, unmarried girls, deserted women or persons above 50 years of age to whom alternative livelihood have not been provided or cannot be provided immediately and who are otherwise not included as part of the family. Families who are landless and living below the poverty line and have been living in the affected area continuously for at least 15 years in cases of non-scheduled areas and 30 years in case of scheduled areas before the date of declaration of the affected areas and have been certified by the concerned Gram Sabha. Such families of scheduled tribes and scheduled caste and other people settled in forest areas who were in possession of forest land in affected areas before December 13, 2005. Now, every survey to be conducted under this should be completed within a period of 60 days from the date of announcement. On completion of the above survey within 7 days, the Administrator for Resettlement and Rehabilitation shall by order publish the draft statement for finding the surveys in such a manner that the person affected may be informed about it and all those likely to be affected by it. Objections and suggestions can be invited from the individuals. Now, after the expiration of period of 15 days from the date of publication of the draft of the survey and details of it, Administrator for Resettlement and Rehabilitation, after considering the objections and suggestions received in this regard, within the next 15 days shall make his recommendation regarding the same along with the details of the survey, will present it to the government, and a copy of it will be sent to the concerned Gram Sabha and Panchayat for general information. Within 30 days from the date of receipt of the details, the survey and recommendation of the Administrator for Resettlement and Rehabilitation, the state government shall publish the final details of the survey in the official gazette. The Resettlement and Rehabilitation Commissioner shall declare any area or areas as resettlement area by order within 15 days of publication of the official gazette, and the details of the survey for resettlement and rehabilitation of the affected families. The resettlement areas will be in adjacent to the project townships. No physical displacement shall be done before the completion of the resettlement work as approved by the Resettlement and Rehabilitation Commissioner. The certificate of completion or resettlement will be issued by the Resettlement and Rehabilitation Administrator in consultation with the concerned Gram Sabha. For the rehabilitation of the affected families, such lands can be used where buildings or houses are not located. The Resettlement and Rehabilitation Administrator will prepare a list of lands that can be made available for resettlement and rehabilitation of the affected family. The list of the ready land will be included in the following. Now, land available or required for the project, land and land earmarked for the project for the purpose, government barren lands, and any other land which is prescribed by the government and is available for allotment to affected families. Land available for purchase or acquisition for the purpose of resettlement and rehabilitation scheme. The Administrator for Resettlement and Rehabilitation may either purchase land from any person through a consent decree on behalf of the state government, enter into an agreement for the purpose, or ask the state government to acquire the land for the purpose of resettlement and rehabilitation scheme. After completion of the basic survey, enumeration of the affected families, and assessment of the land requirement for resettlement, the Administrator for Rehabilitation and Resettlement, after holding consultation with representatives of the affected families, including women and representatives of the acquiring body, shall prepare a draft scheme or plan for rehabilitation. The details of the settlement and rehabilitation scheme or plan shall consist of the following particulars. So this is the plan. Now, the extent of the land to be acquired for the project and the name of the villages affected. Villages and family-wise list of the affected person, including age, extent and nature of the land or immovable property held owned by them likely to be lost. A list of agricultural laborers with their names whose livelihood depend on agricultural activity. A list of person whose livelihood has been lost as a result of acquisition of land. List of non-agricultural laborers including artisans. List of affected landless families including those without habitable land and living below poverty line, which the Administrator for Rehabilitation and Resettlement in consultation with the Gram Sabha will ensure to include in the list. List of persons affected. List of occupiers if any. List of public facilities and government buildings affected or likely to be affected. Description of public or community properties and infrastructure. List of benefits and packages. List of land available for allotment. Details of infrastructure that are to be provided to the affected families. Timetable of reallocation and resettlement of the displaced persons, resettlement areas, and the list of service lands such as Pani, Mato, Mundai, Pardani, or any service land under CNT or SPT Act falling in the project. Educational qualification of the members of the affected families in available employment opportunities and their eligibility. The resettlement and rehabilitation scheme or draft plan shall be discussed in Gram Sabha in rural areas and public hearings where Gram Sabha do not exist. Consultation with the Gram Sabha or Panchayat in the scheduled areas shall be as per the provisions of Panchayati PISA Act 1996. In case of involuntary displacement of 100 or more scheduled tribe families in the scheduled areas, the Tribal Advisory Council will be consulted. The entire expenditure on resettlement and rehabilitation benefits and other expenditure on resettlement and rehabilitation of the affected families will be borne by the acquiring body. Before giving the approval of the concerned plan or scheme, the state government will ensure that the consent of the acquiring body has been obtained before approval of has been agreed to bear the cost of. So they have to agree before this whole process can be started. Now, after given approval to the resettlement and rehabilitation scheme or plan, the state government will publish it in the official gazette. It shall come into force after the final notification of the resettlement and rehabilitation scheme or plan. In case the project in which land has been done by a company authorized to issue shares or debentures, the affected families who are entitled to receive compensation for the land or property acquired shall be given option of taking shares or debentures up to 25% of the amount of their rehabilitation grant. The land acquired compulsory for a project cannot be transferred for any other purpose than the public purpose and such transfer shall be done with prior approval of the state government. If the land acquired for a project or a part of thereof is not used partially for a period of 5 years and fully for a period of 15 years from the date of taking possessions by the acquiring body, the land shall be restored to the possession and ownership of the state government without payment of any compensation indemnity to its acquiring body. The state government will try to establish other suitable projects on that land in case of failure, and the land will be returned to the affected families in case of failure. So the land acquiring body will not have the right to sell the acquired land. Okay. If the land acquired for any public purpose is transferred to any person or organization for any consideration, 80% of the proceeds shall be distributed among the persons from whom the land was acquired. The amount will be distributed in the proportion on which land was acquired. That'll be all for this video. We'll be continuing with the second part of this video in the next video. So, thank you.